Good afternoon, everyone, and welcome to the first virtual CLE program of the Bar Year, sponsored by the Sarasota County Bar Association's Council for Diversity and Inclusion. Today's topic is reconciling the Supreme Court of the United States Dobbs decision with the Florida Constitution's explicit right of privacy. If you are participating in this discussion, then you are probably aware of the Supreme Court's ruling in Dobbs versus Jackson Women's Health Organization, which reversed the 1973 Roe versus Wade decision recognizing abortion rights. Unsurprisingly, the court's decision elicited strong emotions from various people, communities, and organizations. It has raised a number of constitutional and legal questions. We have assembled a panel of highly distinguished speakers with diverse points of views. Our guests have been allotted a certain amount of time to respond to questions posed. Each will provide a response based on his or her interpretation of the law. Additionally, 8 to 10 minutes has been set aside for questions towards the end of the discussion. If you have a question, please put your question in the chat, and our team will review these questions and present them to our panelists during the Q&A portion. We anticipate that several questions will be raised, and we will not have enough time to address all questions on this platform. The case and the court's decision involves complex questions riddled with emotion and passion on every side. Today's program seeks to provide different perspectives and analysis of the court's decision, specifically as it relates to Florida's own constitution. It's safe to say that regardless of your personal views on this topic, it's likely that you will hear points with which you do not agree with. We ask that everyone please keep questions and comments professional and respectful. On behalf of the council, we thank each of you for participating, and we look forward to a fruitful conversation. And now, let me introduce today's guests. Please help me welcome Mr. Alan Perez, who will moderate today's discussion. Mr. Perez serves on the board of the Sarasota County Bar Association and is partner at Millard Perez Law Firm, where he primarily focuses on personal injury litigation. Mr. Perez is a proud graduate of St. Mary's University of San Antonio, Texas, and the University of Dayton School of Law. He has spent his legal career advocating for the injured in court, and he's dedicated to serving his community. Our first panelist is Professor Carolyn Corbin. Professor Corbin is a law professor at the University of Miami Law School, teaching U.S. constitutional law, the religion clauses, the free speech clause, feminism and the First Amendment, and advanced topics in reproductive rights. She holds a BA from Harvard University and a JD from Columbia Law School. Professor Corbin wrote articles that has been published in the New York University Law Review, UCLA Law Review, Northwestern University Law Review, Boston University Law Review, and Emory Law Review, among others. Additionally, she is also a frequent commentator for the local and national media on First Amendment questions. We also have with us Mr. Adam Richardson. Mr. Richardson is a shareholder at Burlington and Rockingback, PA, practicing civil appellate law. He has published several articles in legal and popular media on appellate practice, medical malpractice, civil retrials, and other subjects. Earlier this year, Mr. Richardson authored a law review article titled "The Originalist Case for Why the Florida Constitution's Right of Privacy Protects the Right to an Abortion," where he argues that Florida Constitution explicitly protects the right to privacy for its citizens. And we are also joined by John Stemberger. Mr. Stemberger attended Florida State University, where he studied political science and philosophy before obtaining a Juris Doctor at Cumberland School of Law. Mr. Stemberger held legislative internships in both the Florida House and the Senate and served as an advisor to state, federal, and presidential campaigns, which gave him a unique understanding of the law and government issues. In 2001, Mr. Stemberger was appointed to the Judicial Nominating Commission for the 9th Judicial Circuit of Florida, where he served for 8 years screening and recommending new judge candidates in Central Florida. From 2017 through 2018, he served as a member of Florida's Constitution Revision Committee. To our speakers, we thank each of you for being here today. And now I will turn it over to our moderator, Mr. Alan Perez.
Thank you, Tamara, for that introduction, and welcome everybody to this term's first CLE seminar. We have a very interesting discussion for you today, and I want to get right into it. And we're going to keep time. We have a predetermined amount of time for these answers and this discussion. And so let's stick to it, and I will get into it first by asking Professor Corbin. Firstly, welcome, Professor Corbin. Before we really get it started, we want to set the stage. Could you help us understand the majority decision in Dobbs versus Women's Health Organization and what it really did?
Sure. So we all know that Roe v. Wade established a constitutional right to abortion, and that this summer, roughly 50 years later, Dobbs versus Jackson Women's Health Organization eliminated it. So how did that happen? Well, the US Constitution protects both enumerated rights, those rights explicitly listed in the Constitution, like the right to free speech or the right to free exercise, and unenumerated rights, those rights that are not explicitly listed. The textual support for unenumerated rights, well, frankly, it was supposed to be the Privileges and Immunities Clause, but it's now the 14th Amendment's Due Process Clause. It's part of the liberty that no state should deprive any person of. Notably, Dobbs does not believe that the US Constitution protects both enumerated and unenumerated rights. What Dobbs does change, however, is how to determine which unenumerated rights merit constitutional protection. In previous decisions, the Supreme Court held that abortion was fundamental to both autonomy and equality, and that's why it deserved protection. It was fundamental to autonomy, both bodily autonomy, decisional autonomy. So bodily autonomy, meaning the right to control what happens to one's body, decisional autonomy, meaning the right to make major life decisions like whether to have a child. And these were parts of the privacy rights that the Supreme Court had recognized. The court also had acknowledged that abortion was fundamental to women's equality in that we cannot participate as equals in the social, economic, and political life of the country if we cannot control our reproductive lives. Dobbs, however, took a more originalist approach and held that the appropriate test to determine unenumerated rights protected by the US Constitution was to ask whether a contested unenumerated right was deeply rooted in our nation's history and tradition. And according to the court's historical analysis, which looked at whether the right to abortion existed at the time the Due Process Clause was enacted in the late 19th century, and it concluded that the right to abortion is not deeply rooted in our nation's history and tradition. Now, the Supreme Court had previously rejected making 19th century, when the Due Process Clause was enacted, the touchstone for our fundamental rights today. It may be a starting point, but not the end point it had held in earlier cases. After all, as the dissent pointed out, the historical approach means that 19th century views of women might determine our rights in the 21st century. And some of the 19th century views of women are pretty outdated, such as women should not vote or married women should not own property. But the bottom line is that abortion is no longer protected by the US Constitution because it is not deeply rooted in our nation's history and tradition. So this does not mean that abortion became illegal overnight across the nation. Instead, it means that because the US Constitution no longer makes it unconstitutional to ban abortion before viability, each state may determine for itself whether to allow abortion or not. In Florida, the legislature passed abortion at 15 weeks. That ban no longer violates the federal Constitution. But now the question is whether that 15-week ban violates the Florida Constitution, which, unlike the federal Constitution, expressly protects the right to privacy. That's it. That's the, I hope that leads up. I hope I queued up my colleagues' presentation about Florida now.
You were actually short on your time, and I appreciate that. So does everyone else. And I want to shift gears, and I appreciate the transition, because I'm going to direct the next question to Mr. Stemberger. It was 1980 when Florida amended its state constitution to provide protection for individual privacy rights. And so, springboarding off of what Professor Corbin set up for us, Florida banned access to abortions after 15 weeks. Does the ban run afoul to Florida's constitutional right to privacy? We'd like to get your thoughts on that.
Sure. First of all, I want to thank the leadership of this county bar for doing this forum. I'm not aware of another forum like this anywhere, even in law schools. So this is really an outstanding forum to help people understand what these issues are. So in 1989, the Florida Supreme Court decided the case of In re TW. There was a special legislative session on abortion. Specifically, a parental consent bill was passed requiring minors to get one parent's consent before an abortion is had. That bill immediately went up on appeal. The minor's initials, to keep her confidential, was TW. So the case is In re TW in reference to In re TW, a minor. That case is our state Roe versus Wade case. It is a case which established a fundamental right to abortion, at least according to the case law and the judge's opinions, which is more expansive than even Roe versus Wade. The problem from our standpoint is that the court did this completely sua sponte, out of nothing. And the history behind the privacy right, which is in 1980, I want to make 4 points about that. Number one, the plain text. Number two, the second sentence of the right. Number three, the history behind it. And number four, who was supporting it and opposing it at the time in 1980 when it was adopted. You have to go back to the early 70s, because the watershed issue in the 70s was Watergate. This was kind of obviously not as significant as 9/11, but this was an event which really was kind of indelibly marked upon the public's mind because of the scandal involved, the corruption, and the fact there was widespread wiretapping. In 1974, in response to this, Congress passes the Privacy Act, which also commissioned a privacy commission. And that commission would study the informational privacy for 2 years. In addition, you had TCP/IP protocol first being invented by two gentlemen, Vint Cerf and another gentleman. It's actually like the TVs, the internet's actually came about by a committee. You had fax machines coming on the scene. You had SWIFT, which is international banking wire transfers. All of these things are happening for the first time in the 70s. And so there's this kind of explosion in concern about informational privacy. So the Privacy Commission studies it for 2 years, and they determined in 1978, when they issued their report, that states should actually look at the concept of privacy, because there's no express privacy clause in the federal constitution, much less informational privacy. Well, the first Constitutional Revision Commission was meeting in 1978, and they actually saw this as a trend. They wanted to do something that was relevant. They debated it and discussed it, and they passed out a one-sentence amendment, but the problem was it was chucked with about 67 other parts of the Constitution on one amendment. So in 1978, that failed. The legislature came back a year later in 1980, and they adopted the same language, but they added a second sentence. And the reason that's significant is because all the media, all the daily newspapers, their editorial boards, they opposed the Privacy Amendment because they didn't think they would be able to get information. They didn't think they would access public records, because all the debate, all the discussion was about data collection, informational privacy. Literally in the entire CRC's debate and discussion, there's no reference whatsoever in any record to substantive due process, abortion, personal autonomy. All the discussion and debate is centered around informational privacy. Now, in the legislature, there are a couple of references. In 1980, there are a couple of references to abortion, but they're basically denials, saying this has nothing to do with abortion, at least when Jack Gordon is debating Senator Ed Dunn on the floor of the Senate. So all of this kind of events, this kind of informational privacy, and this is what the people thought about when they were voting in 1980. And in fact, all the people who are pro-life advocates at the time, the Catholic Conference, Tom Horkin, Carol Griffin, who was kind of the pro-life advocate in the legislature in Tallahassee. None of them objected. None of them had any problems with this because it was all about informational privacy. And so that's a very interesting thing to know. That's how it was kind of adopted. So the whole context was informational privacy. And our contention is that the court in 1989 improperly looked at that. They ignored the legislative intent. They ignored the kind of intellectual form that this whole thing came about, much less the plain language, which says nothing about abortion. And the second sentence basically says this section shall be construed, not be construed to limit the public rights access to public records or meetings. And the legislature put that in there because they were concerned about the media, right? Being concerned about informational privacy. And so it actually passed in 1980 by 60% after they added that second sentence. And they didn't chock it full with 67 other amendments. It was actually a standalone where people could understand what it was. So our contention is for the same reason that the US Supreme Court overturned Roe. We believe that the Florida Supreme Court could and should overturn in re TW because the legislative history behind it, because the plain language, because of the original meaning of the people that adopted it had nothing to do with abortion. And it all had all to do with information privacy. Even the language of the right to be let alone, this comes from a famous law review from Justice Brandeis that deals with intellectual property, deals with kind of these kinds of things, not anything about substantive process or abortion. Even the word government intrusion, the word intrusion literally means the wrongfully taking of the possession of another person, as in taking their private data or their property. So the plain language, the history behind it, the text, the second sentence, and those who are supporting it and opposing it point to the fact that this was intended for informational privacy and not abortion.
Okay, well, we certainly appreciate the context, and I think that what I want to do now is turn it over to Mr. Richardson. Same question to you, sir. Given the 1980 amendment that provides protection for individual privacy rights, does this Florida ban access to abortion after 15 weeks, does it run afoul to Florida's constitutional right to privacy?
Yes, first, of course, thank you for having me. Under the existing law, as Judge Cooper found earlier this year, yes, the 15-week ban does violate our state constitution's right of privacy. So I'll talk about that briefly, but then I want to talk about also the original public understanding of Section 23, the right of privacy. Under Florida law, when a law implicates the right of privacy, it's presumptively unconstitutional, and it must pass strict scrutiny. And the burden at that point, because it's presumptively unconstitutional, shifts to the state to prove that it has a compelling state interest and that it's furthering that state interest through the least intrusive means. Here, Judge Cooper faithfully actually applied existing Florida law to find that this was unconstitutional because it didn't pass strict scrutiny. There were two asserted interests, and those are the interests that were recognized in re TW, which John just talked about. The first is maternal health, and the second is the potentiality of life in fetus, represented by the fetus. And I'm not going to get into the details of that, but the judge found, based on the facts he found following the evidentiary hearing, that the state failed to prove that the law furthered compelling state interests. It's actually a very lengthy analysis. It's a 68-page order, very interesting reading. But so on that discrete question under existing law, is it unconstitutional? I think the answer is yes. Judge Cooper was correct to find that. On the original public meaning of Section 23, I think John is correct that to a point. Yes, obviously Section 23 was designed and voters intended that it would protect informational privacy. And I think Watergate is an important context, but that ignores entirely other important contexts, such as the development of the right of privacy and especially the right of abortion, starting in 1973 and continuing through that decade. Then at the same time, after 1973, as Justice Alito, writing for the court, emphasized several times in the Dobbs opinion, Roe just provoked a firestorm. It actually led to the creation of a prominent national pro-life movement that sought from the get-go to undermine the protections Roe afforded to women. So all of that was actually in the public's mind at that point, that the right at that point could be undermined later. And as Professor James Fox writes, of Stetson Law writes in his own forthcoming law review article, the right of privacy was not something that would have been extensively debated in 78 or 80, because at that time, the right to an abortion was already kind of baked into the public understanding of the right of privacy. And that was settled. It wasn't necessary. What did happen in 1978 and 1980 were discussions about what could be called like cutting edge legal issues, such as gay rights, which featured prominently in the debates, but also in the debates, as I found from newspaper articles in those years, the people focused extensively on the right of decisional privacy, not just the right of informational privacy. They, both opponents and proponents of Section 23 said that this would be a very broad right, that it would mirror or exceed the rights protected by the federal Constitution, and that it would protect both informational privacy, as John says, but also decisional privacy. And so we have those two different components, the background, legal and historical, and then also the specific background, the public debate in 78 and 80. And that has led me to conclude that it was the original public understanding of the voters who adopted the amendment, that it would protect the right to an abortion. And on this point, this is the last thing I'll say, and I hope I haven't taken up more than my time. I'm not the only person who thinks that. There's Professor James Fox, of course, but in the course of my research, I found an article that now Chief Justice Carlos Nunes wrote in 2004 for the Journal of the James Madison Institute, while the 2004 proposed constitutional amendment authorizing the legislature to enact a parental notice requirement was still before the voters. And in that article, he writes the following paragraph. The people of Florida in 1980 amended the Constitution to add a right of privacy. At that time, 7 years had passed since the US Supreme Court established the abortion right in Roe versus Wade. Already there was widespread acknowledgement of the vulnerability of any right that lacked explicit support in the constitutional text. In that context, one purpose of the Privacy Amendment clearly was to give the abortion right a textual foundation in our state constitution. That is, as I said, now Chief Justice Nunes writing in 2004. I found this after I had already completed and submitted my draft law reviews. And I think that is an eloquently and briefly stated capsule of the position that I and James Fox have advocated. And so that's kind of my position about the original public meaning of Section 23. Thank you.
Well, thank you very much, Mr. Richardson, for that perspective. This next question, we have allotted 3 minutes per panelist to provide a response. I'm going to start off and direct it to Professor Corbin. Several lawsuits have been filed in Florida as a result of the 15-week ban. The critical question, of course, that the Florida Supreme Court will have to answer is, does the presence of an explicit privacy right in the state constitution mandate a different holding in Florida than that in Dobbs versus Jackson Women's Health? And how should the court answer this question? You're on mute, Professor Corbin. It doesn't count. It's your time, though. It's okay.
Yeah, okay. So there are several reasons why the outcome should differ, and I think there is one reason why none of those will matter. One point I want to make is that even if the language of the Florida state constitution were exactly the same as the language of the federal constitutions, states could choose to interpret it differently. In other words, Supreme Court interpretations of the federal constitution do not control state court interpretations of their own constitutions, even if the language is the same. So I just want to focus on that. But of course, the language of the Florida Constitution is different from the language of the federal Constitution it explicitly protects privacy rights. And I'm going to read it so that people know what exactly it provides. It says, right of privacy. Every natural person has the right to be let alone and free from governmental intrusion into the person's private life. Frankly, I'm not sure we really need all the very interesting historical analysis that we've just heard, because under the plain meaning of the language, the government should not interfere in a person's private life. And it's really difficult to imagine a greater governmental intrusion into your private life than the government forcing you to carry a pregnancy for 9 months against your will. So I think the plain meaning of the text pretty much covers decisions like whether or not to stay pregnant. Third, the Florida Supreme Court is not interpreting this provision for the first time. It has already held in multiple cases that Florida's right of privacy does in fact cover abortion. So the question is really one about stare decisis. Is it appropriate to overrule the controlling precedent? Now in Dobbs, the US Supreme Court could argue that Roe was clearly erroneous because there was no right to abortion when the Due Process Clause was enacted. But it is hard to make the case that the Florida Supreme Court was clearly erroneous when it repeatedly held that the right to privacy covers the right to abortion. So first, as I said, I think the plain language seems to encompass the right to privacy. And second, at the time the amendment was enacted in 1980, as Mr. Richardson pointed out, the right to privacy was widely understood as encompassing a right to abortion. So it is not clearly erroneous to find that Florida's right to privacy protects abortion, and therefore the precedent should really stand. And the one reason why the Florida Supreme Court may nonetheless follow Dobbs is that, like the US Supreme Court, the Florida Supreme Court has taken a very sharp turn to the right.
Understood. Thank you for that perspective, Professor Corbin. Now to Mr. Stamberger, same question. There are several lawsuits that have been filed. The question the court has to consider, of course, is whether or not this explicit privacy right mandates a different holding than that of the Supreme Court for the US. How should the court answer that question?
So I think that we have to remember that the unique privilege of Supreme Courts is that they can look at the Constitution with fresh eyes. They are not bound by the precedent of even their own court. And so for the same reason that the court in Roe overturned Roe, because it does not have an express right to abortion in the federal Constitution, I think you're going to see the same analysis. The court did not take a turn to the right. The court took a turn toward textualism instead of using, as I like to call it, legal Play-Doh with the 14th Amendment, making up rights out of thin air when they're not expressly stated in the Constitution. So it's a whole nother framework of looking at a document in terms of actually seeing the text. Words have meaning. And so it's a whole different perspective of interpreting. And I think that's why the court is likely to overturn In Re TW. At the time in 1980, Roe is good law for 7 years. The only discussion about abortion going on is at a federal level. There's a federal human life amendment. But even in the 1980 campaign between Reagan and Carter, they both actually agreed to prohibit federal funding of abortion. So there's actually not a lot of debate and discussion around abortion in the 1980 election. It wasn't a keynote issue. I remember voting for Jimmy Carter because I thought Ronald Reagan would blow up the world, right? And I think I voted for the Privacy Amendment as well in 1980 at that time anyway, as a Democrat at that time. So yeah, we just don't see this concept of informational privacy versus decisional privacy. There's no context either in the Constitutional Revision Commission or in the legislature. Clearly, the right is broad. There's no question about that. The language is broad, but it's not all encompassing. In other words, not without limitations. And so all of the history behind this, all the debate behind this, even the pose that opposed it, no one was talking about abortion at all. There's literally no mention at all in the Constitutional Revision Commission debate in 1978, no reference whatsoever. In 1980, there's 4 references. 2 are from news articles where actually gay activists who are being quoted by the media are talking about it in passing. They're saying it could affect abortion rights, not lawyers, those activists were. And then there was one debate between Senator Gordon, who is the Senate sponsor, and Senator Ed Dunn, who is a Catholic senator from Daytona Beach, asking him specifically, hey, this is going to affect abortion. And Senator Gordon, the sponsor, says, no, absolutely not.
Okay, understood. So now over to Mr. Richardson, same question, 3 minutes on the clock. The question the court has to answer is whether or not the presence of this explicit privacy right of mandates a different holding than the U.S. Supreme Court. How should the court answer that?
I think the answer is yes. I agree with Professor Corbin. As you said, you start with the text, and the text is extremely broad. I know John and the state believe that the inclusion of the word "to be let alone" implicates the very narrow understanding of privacy in the Brandeis co-authored article in the Harvard Law Review from the 19th century. But I think, as I demonstrated in my article, that "to be let alone" has always had an extraordinarily broad understanding, much broader than informational privacy. And I think at that point, the burden will need to be on the state and pro-life activists to prove that when it came to the 1980 amendment, that much narrower understanding penetrated into the public consciousness to agree that it displaced what otherwise is a very broad meaning. I think then Professor Corbin mentioned something about stare decisis. I think that's also pretty interesting because in re TW was decided in 1989, which was fairly contemporaneous with the 1980 amendment. All of those justices would have been alive and aware of the public discussions. And they decided that the right included a right to an abortion. And in fact, one of the more interesting things I found is that in post-OA briefing in the Supreme Court, the parties extensively addressed, and the amici extensively addressed original understanding. And even with all of that briefing, the court still decided that, yes, this right implicates the right to an abortion. And I think if you're asking whether the case law clearly conflicts with the Constitution, you look at, were these people who experienced this wrong? And then you look at also the historical evidence that I and Professor Fox have marshaled and ask, if that is even arguable, then can we say that in re 2W was clearly erroneous? And I don't think you can. Another thing I wanted to correct is something John said about the state discussion. So there was something at the federal level, the kind of the fetal personhood amendments, but that also happened at the state level in the Florida legislature a few times in the House of Representatives. A representative tried to pass one of these amendments, try to get it on the ballot, and it failed. At the same time, in the 1980 presidential election, obviously abortion was a huge deal. Reagan was unavowedly pro-life. I mean, this was huge, and I understand that from a political science perspective, whether that discussion actually had an effect on the outcome of election is disputed. But you can't say that it wasn't a big deal. Pro-life activists, religious organizations supported Reagan because of his pro-life position. That's a matter of historical fact. And another thing that as I said before, it makes a lot of sense that abortion just wasn't mentioned in 1980, because by that time it was settled. Everyone knew that at the federal level, the right to privacy included a right to an abortion. It wasn't a matter that needed to be litigated at that point. What they were doing more of was like the right to cohabitate, gay rights, the right to smoke pot in your house. Those were like kind of the cutting edge issues that were of concern to people at that time, but abortion wasn't one of them because, as I said, it was already settled. That's probably eats up all of my time, so thank you.
Okay, yeah, no problem at all, and we certainly appreciate that response. We're going to move on to a different question. Same time frames apply. We've allotted 3 minutes to respond to this. Professor Corbin, does the Dobbs decision jeopardize other substantive due processes rights, such as the right to contraception or the right to same-sex marriage?
Yes, it does. Now, the US Supreme Court in Dobbs insisted that abortion was different and that it was not planning to eliminate any other fundamental substantive due process rights. However, the new test the Dobbs court created for evaluating unenumerated fundamental rights allows them to do so. So recall that according to the Supreme Court, only those unenumerated rights that are deeply rooted in our nation's history and tradition are protected by the US Constitution. And it would be quite easy for the Supreme Court to construct a history where the right to contraception was not deeply rooted in our nation's history and tradition. And it would be very easy for them to argue that the right to same-sex marriage is not deeply rooted in our nation's history and tradition. So the new doctrinal test for substantive due process rights really opens the door to eliminating more established rights. And there's really no principle in Dobbs preventing the court from doing so. Now, the conclusion is not inevitable, even given the new doctrinal test, because the answer to whether something is deeply rooted in our nation's history and tradition very much turns on how the right is framed. So, for example, instead of asking whether the right to same-sex marriage is deeply rooted, the court could ask whether the right of two people to marry is deeply rooted in our nation's history and tradition, and conclude that, why, yes, it is, which is in fact what the Supreme Court did in Obergefell, which is a Supreme Court case that established the constitutional right to same-sex marriage. And frankly, the right to abortion could have been framed instead as the right to medical decisions concerning one's own body, in which case you might conclude that the right to make medical decisions about your own body is in fact deeply rooted in our nation's history and tradition. So basically, the Supreme Court has the ability, depending on how it frames the contested right, to either reaffirm or eliminate other substantive due process rights. So that's the constitutional analysis. Now, the political analysis may differ, especially given the political fallout of eliminating constitutional right to abortion. So I don't know whether they will or not for political reasons. But as a constitutional matter, the door is definitely open to eliminating additional fundamental substantive due process rights.
Okay, well, thank you for that. And so I'm going to shift over now to Mr. Stenberger. Same question. Does the Dobbs decision jeopardize other substantive due process rights, such as the right to contraception or the right to same-sex marriage?
It clearly does not. Of course, Clarence Thomas had the correct legal answer. He says substantive due process is, again, legal Play-Doh. It's nonsense unless the right is expressly enumerated in the charter. You don't recognize it, and that's clear in our tradition and history. However, the problem is 4 justices that are conservatives, right? Conservative in terms of their mode of interpretation of the Constitution said, hey, this is not going to apply to anything other than this case because it involves the taking of another human being's life. And they distinguish it based upon that as well as the history analysis. So clearly, I mean, folks have tried to use this as a scare tactic and to try to get people all upset. But, unless you eliminate 9 votes on the Supreme Court, which is not going to happen in any of our lifetimes with a completely different viewpoint, there's no other issue. I don't see how this gets oxygen from a legal standpoint. Now, I will say this, it's possible that given the holding in Dobbs that they could find some other means, let's say the 9th Amendment or the concept that, that this is reserved for the states or something else. But I think in terms of substantive due process as a theory, they pretty much blocked themselves in. The entire court said, no, this is not going to change. And I predicted literally 10 years ago that the Supreme Court, which by the way is a political body, it's also an academic body, they would split the culture war baby. They would be pro-gay rights, but they would also be pro-life in their orientation. And that's in fact happened. So I don't think this is going to change anytime soon. you'd have to have 9 justices change their mind, and I don't see that's going to happen in any administration.
Okay, and I am going to ask Mr. Richardson for his perspective, but there's a question that got posed in the chat that I think is directed to you, Mr. Stenberger. Didn't Justice Thomas specifically state that he thought the rationale of Dobbs could be applied to prior cases involving contraception and same-sex marriage?
Yes, he did, absolutely. But he was alone in that opinion. And I think he's right, correct legally. He's taking the correct legal position, but none of the other court members agreed with him. So again, you have one lone dissenter having a unique view that's not shared by anybody else on the Supreme Court.
Okay. So, Mr. Richardson, same question to you. Does the Dobbs decision jeopardize other substantive due process rights, such as the right to contraception or the right to same-sex marriage?
My views on this are less well-formed than the other panel members, but I agree that Justice Thomas's with Justice Thomas and John and Professor Corbin, that the rationale of history and tradition and implicit in the concept of word liberty test will make it very difficult to justify these kinds of rights, to procreation, contraception, to same-sex marriage. Even possibly back to being able to marry a member of a different race. And Professor Corbin's right, like this is not a very persuasive distinction that Justice Alito offered, because you have the test, history and tradition, and implicit in the concept of ordered liberty. And the idea that these other cases are different because abortion implicates potential life, it doesn't fit neatly into that standard at all. It doesn't engage it. So how can that be a potentially dispositive distinction under that analysis? And I don't think it is. But I think, as we all recognize, the justices are fairly political. It's a political body. And if they want to insist on that distinction, as unpersuasive as it is, then you can do that.
Sure. Okay. So we have one question in the chat from Mr. Barry Spivey, and I want to read that to you. I'll direct it. We'll start with you, Mr. Stenberger. Do you agree with Thomas Jefferson that there is nothing sacred about a constitution and that they should be changed frequently to meet the changing needs of the people?
Well, first of all, I just Google searched that when I found it. Thomas Jefferson, nothing sacred. I can't find that anywhere, so I'm not even sure that's an accurate quote. But to the concept of the living and breathing document, I would say that absolutely the Constitution of living and breathing, as it is properly amended by the people, not by judges who feel free to insert their own values into the text, right, and become activists essentially beyond the scope of the text of the Constitution and the history of the Constitution. So that's the problem that we have, is judges who view themselves as social change agents, not intellectual academic arbiters of the law and the letter and the text of the law. And this is this whole debate that's been going on. And I think now you're seeing, because of largely the work of the Federalist Society, you're seeing many, many judges return to this concept that actually words have meaning. We're not going to just act as if they don't exist. And we're not going to imply things and kind of make rights up just from generic liberty interest. And so I think that, yeah, we should have a living and breathing document as it's properly amended, not by the judges.
Professor Corbin, your thoughts?
So here's the thing about the Constitution, is that it's a really short Constitution. It's one of the shortest constitutions in the world. And that's because often what it's doing is establishing certain broad standards rather than explicit rules. So take something like the Equal Protection Clause, right? Clearly it's trying to embody some idea that people should be treated equally. But what that means may change over time. And when the Equal Protection Clause itself was enacted, segregation was a given. And so if you want to insist that we pin our understanding to equal protection to how it was applied at the time it was enacted, I think that's contrary to the understanding of the people who wrote the Constitution themselves, which really viewed it as a framework with some basic principles, and how those principles would apply would progress as the nation progressed. And in fact, that is in some ways how we have understood our Equal Protection Clause, because we have not sort of tied it down to the 19th century understanding of what it demands, and has expanded it as we have recognized that we really don't want anyone to be a second-class citizen based on their race or on their sex or on their, as we're coming into the 21st century, sexual orientation. So I don't think it's so much that we're changing the Constitution, but we are applying its basic principles in ways that conform to the general understanding of what they require.
Thank you for that. Thank you. Mr. Richardson, your opportunity to respond. The Constitution, should it be changed frequently to meet the needs of the people?
It's a difficult and interesting question because in Florida, the Constitution is very different than the federal Constitution. In contrast to the federal Constitution, our state Constitution is easily amendable. We saw that just, I don't know when the election was, there are 3 amendments, they all failed, but these are put on, proposed amendments are put on the ballot every cycle, and the voters have their say. We're able as voters now to amend our Constitution to reflect our views. So in that sense, I think the Florida Constitution is more of a living and breathing document. And I think Section 23 of the Right of Privacy Amendment is a perfect example of that, because we did not have a right of privacy under our state constitution before 1980. The Florida Supreme Court refused to find one, as the US Supreme Court had. And we decided that we in our state wanted something different. So we adopted it. And that was in that way, we were able to change the actual text of the Constitution to reflect our changing views as a society. And so it's not quite the same. I don't have quite the same answer for the Florida Constitution that I have for the federal Constitution. That's really just the basic position I have. And for the Florida Constitution, I think it's easier to make the case that it can and should be viewed as something a little bit more living.
Okay. There's another question we have that's been posed. I'm going to direct this one first to Mr. Stenberger and then Professor Corbin, and then you, Mr. Richardson. But Mr. Stenberger, for the past 50 years, law school students have been taught the Roe v. Wade case and the concept of stare decisis and precedent. With the overruling of Roe versus Wade, how does this affect the way you teach con law to students?
So that's a great question. Sounds like one for the professor primarily, but so there is this concept called adequate and independent state grounds, where a state can provide more rights than the federal Constitution if they want to, right, via the amendment process or their interpretation of it. The federal Constitution provides a floor, the state Constitution provides a ceiling. And so that's a dynamic and a legal concept that we have to understand in order to interact with these things. It doesn't necessarily mean that every state constitution is broader, it just means that it's possible for the state constitution to have more rights than the federal Constitution. It can't have less, but it can have more rights in a given area. So I guess that would be my only comment. And I think this is mainly for the professor, actually. So.
Sure. Yeah, Professor Corbin, how do you teach now? How does this change what you have been teaching to constitutional law students?
Yeah, so actually I'm teaching a course on the First Amendment right now, and I'm in the last quarter, which is on the Establishment Clause, which is being radically remade before our eyes. So it's a real challenge to teach it at all, because it's not clear what's still good law, but more focused on Dobbs. I think one of the reasons Dobbs was so disturbing to many is not just that it overruled precedent to contract rights, which is really rarely occurs, but that it ignored the precedent on precedent. So generally, there are rules about when it's appropriate to overrule something and not overrule, and it includes things like, has there been a major change in the law since the decision? Has there been a major change in our factual understanding? Is the decision unworkable? And instead of really focusing on those, the Supreme Court made up a completely new test for deciding when something should be overruled or not. And one of it was it a really bad decision? And do we think the reasoning is really bad? And do we think this is a really bad decision, distorting other decisions? Just sort of, into forms of teaching, I mean, that's what I teach. This used to be the rules on precedent. Now we have new rules on precedent. What does that mean going forward? I mean, a lot of times the only thing you can do is just say, here's the change. I don't know what it means. I don't know if it's just for this case or whether these are the new rules going forward. And we need to wait for further decisions to see how this all unfolds. But I think the question underlying that is a question about, we try to teach constitutional law as a rule of law that is reasoned and principled. And how do you reconcile that with a decision that seems so unprincipled and politically motivated? And that's a harder question. I think that there's always been politics mixed in with Supreme Court decisions, and that's something to acknowledge as you go along. But I think that's a fair question, is how much do you emphasize that fact of Supreme Court decision making? And I think that's something everyone sort of feels as they go along. Sorry, that was a long answer, but the longer the answer, it means the less sure I am of it, because I'm not 100% sure how to deal with something like Dobbs.
Understood, and I don't think any truer words have been spoken. The same thing for me. The longer I speak, it's just indicative of the less I know, the less I'm sure. I want to give you, Mr. Richardson, a chance to jump in the professor's shoes and answer or give your perspective on the concept of teaching the people that are future lawyers. You know, how does this affect them or that teaching?
I don't have any strong views on that because I'm just a practicing lawyer. But I can tell you that this does affect my practice. Professor Corbin talked about how they kind of reworked precedent on precedent in Dobbs. The Florida Supreme Court already did that in State versus Poole, a 2020 case, where it formally weakened the doctrine of stare decisis. So now, from 2020, we really only ask whether previous Florida Supreme Court precedent clearly conflicts with the higher legal authority or was clearly erroneous. So we've been operating under that regime for a couple of years now. And I'm a plaintiff's lawyer and appellate lawyer. There are a lot of decisions from before 2019 that are pro-plaintiff, particularly in the medical malpractice field, which is one of the big parts of our practice. And in our practice, in the arguments that we make, in the advice we give trial lawyers and clients, we always have to consider, will this decision we're relying on now that is good law still be good law in a couple of years if this goes up on appeal? So at least from a practical matter, it does affect how I practice, and I'm sure how others in my field practice.
Okay. Thank you for that perspective. There's one more question in the chat. Just a couple minutes, then I'll give everybody to respond. The legal arguments presented today do not address the often heated claims that the fetus is alive either at the moment of conception or sometime later. Do you believe the courts are influenced by these claims? How does the personhood of the fetus impact the court's position, or does it not? Mr. Stenberg.
Yeah, so this is a great question. Before I answer that, I just want to make one statement. Lawrence Tribe, who's the leading expert on privacy at Harvard University, wrote the law, the Horn book on this, basically thinks Roe versus Wade is bad law. I mean, just looking at it objectively, he thinks it should be rooted in the Equal Protection Clause or something more suited. But the case itself really is very poorly decided from a legal standpoint. And there's a lot of even, left-leaning pro-abortion advocates that would agree with that. As for the personhood question, this is exactly right. People that are debating the issue as a policy matter can no longer say, oh, it's just a blob of tissue or something like this. Everyone knows now that in mommy's belly is a baby, right? And so the issue is no longer whether it's a human life. We know scientifically that life begins at conception, ends at natural death. That's not my opinion, that's just a scientific fact. The issue legally now is when are we going to grant personhood, right? And this is the issue that you have in history and other cases. In Dred Scott, personhood is the status of being provided protection and rights under the Constitution. And sadly, the unborn child has no protection at all until the child is literally out of the womb. So it is basically this, I would argue it's discrimination based upon age and location. If the child is located literally outside the mother's womb instead of inside the mother's womb, magically the child now has rights. Inside, the child has no rights. And so this is an injustice, but that is the legal issue. And until we establish that the unborn child is a person under the law, that's really the ultimate protection and the ultimate pro-life position that I think those of us in our movement are fighting for.
Professor Corbin, I see you.
I have many thoughts.
Yes, I think so.
One thing I want to clarify is that the abortion can be banned at the point of viability. So it is not true to say that the unborn fetus has no rights until it is born. I 100% agree that the view that life begins at conception is informing the Supreme Court's decision. And indeed, that is the reason why abortion is different from all the other substantive due process rights. I do not agree that clearly a fertilized egg inside a woman is a human being, but the question is, does it have the same moral status as a person? And that is not something that is universally recognized. In fact, one of the most interesting challenges to Florida's 15-week abortion ban is actually a religious liberty claim brought by Jewish women, because under Jewish law, the pregnancy is considered part of the woman until birth. And so also under Jewish law, anything that threatens the woman's well-being, either physically or mentally, must be brought to an end. So under a different religious viewpoint, right, under Jewish law, there may be circumstances in which abortion is mandated. And so the Jewish women are arguing that banning abortion at 15 weeks may actually force them to violate their own religious requirements and denies them the right to live according to their own faith. So again, I agree that the view that life begins at conception is informing the Supreme Court decision. The point I want to make is this is one particular religious view on when life begins, and not necessarily a view that is shared by everybody.
Understood. Mr. Richardson, any comments?
As a practicing lawyer, I can't really talk a lot about what I think justices will do or what they'll take into account. I think that it is, people have very strong views on fetal personhood. I think if there are justices on the court that have strong views on that, it will probably inform the ultimate outcome. Maybe not explicitly, maybe just because that's what their inclination is. I will note that Justice Kennedy was a politician for a long time before he was a judge, both in the state house and then in the US House. And he has an established record of trying to work fetal personhood into the law. It's obviously a strongly held personal belief. Will that affect his decision-making in this case when it is squarely given to them for a decision? I don't know, but as a human being, What do we think about that? Does that affect how people decide things? Yeah, so we'll just have to wait and see though. I think, yeah, Professor Corbin's right that in the Dobbs decision, Alito makes a lot of references to unborn children and stuff like that. So it's very clear that he's on the fetal person bandwagon. And ultimately it did, I think, explicitly affect his decision-making in that case. But again, don't know.
Okay, understood. We are at our time, and I wanted to just make one comment. There was one question in the chat about getting the citations for your sources or the articles that you mentioned. And what I can tell our viewers is that we'll try our best to make sure we secure those from the panelists. I want to take one more opportunity to thank our panelists for being here, giving us your time. It's a very important topic. I'm sure we could be here for many, many hours talking about this decision and stare decisis and precedent and all those wonderful things. What I want to tell our viewers that we will have this recording available for viewing on the Sarasota County Bar Association YouTube channel. Don't forget to like that, share it with your friends and colleagues on your preferred social media channels. And thank you everyone for watching. Thank you again, panelists, for your time today.
Thank you.
Thank you for having us.
Thank you, Alan.